Okay, so this is Marine Flag's motion for a preliminary injunction. What she's seeking basically is to stop Taylor Swift from continuing to use the God, I can't remember now the life of a showgirl. I was about to say confessions. See, that's what she's saying here. Is like they're similar. It's confusing. I was literally about to say confessions of a showgirl. No, Taylor Swift is the life of a showgirl. So she's trying to basically say, hey, can you stop her from using that? Because it's confusing. Can you, at least until this is settled? So this is a preliminary one. She's also going to be requesting a permanent one as part of her complaint, but this is a preliminary injunction that is just for the purposes of, until whilst this action is still pending. Okay. And then the next video I'll do will be Taylor Swift's quite harsh response to it. Okay. Please take notice that on May 27th, 2026, at 1:30 p.m., or as soon as the matter may be heard, in the courtroom of the Honorable Serena Murillo at the United States District Court for the Central District of California. I'm not going to read the address. Plaintiff Marine Flag, professionally known as Marine Wade, will and hereby does move for the court for a preliminary injunction against defendants Taylor Swift, TAS Rights Management, UMG Recordings, and Bravado International Group Merchandising Services. Pursuant to Federal Rule of Civil Procedure 65 and Local Rule 65.1. As detailed in the proposed order submitted with this motion, plaintiff seeks an order enjoining defendants together with their officers, agents, servants, employees, attorneys, and all other persons in active concert or participation with them during the pendency of this litigation from using the life of a showgirl as a trademark or source identifying designation in connection with any goods or services within the classes of goods and services identified to the United States Patent and Trademark Office in defendant's U.S. trademark application, including but not limited to merchandise, consumer goods, and entertainment services, pending final resolution of this matter. This motion is made on the grounds that 1. Plaintiff is likely to succeed on the merits of her claims, or, at minimum, her claims raise serious questions going to the merits. 2. Plaintiff will suffer irreparable harm if defendants are not enjoined. 3. The balance of equities tips sharply in plaintiff's favour. And 4. The public interest favours the issuance of a preliminary injunction. This motion is based on this notice of motion and motion, the attached memorandum of points and authorities, plaintiff's complaint, the declaration of Marine Flag, the declaration of Jamie Parkinen, and associated exhibits, all matters of which the court may take judicial notice, all other pleadings on file in this action, and any other further written or oral argument or evidence as plaintiff may present to the court. Although not required by Local Rule 7.3 or the court's standing order for applications under Federal Rule of Civil Procedure 65, plaintiff's counsel contacted counsel for Swift and TAS on March 30th, 2026 to discuss potential resolution of these matters without judicial intervention. Those discussions were not successful. Okay. Memorandum of Points and Authorities Introduction. In 2014, plaintiff began writing a column in Las Vegas Weekly about life as a working performer. The indignities, the absurdities, the giant birthday cakes you get trapped inside, and called it Confessions of a Showgirl. It sounds like a blast. It sounds so fun. I'm interested now. I might go and look it up. Over 12 years, she built the brand into a live show, a touring production, a book, a podcast, and a federally registered incontestable trademark. For more than a decade, the mark identified a single source. A search for it returned one person. Then, in August 2025, defendants adopted the life of a showgirl. Within weeks, the name appeared on drink tumblers, candles, hairbrushes, and garment tags. Defendants built a dedicated retail storefront around it, launched collaborations with numerous national brands, and filed a trademark application across 14 international classes, covering everything from disposable napkins to ponchos. They never contacted plaintiff, they never sought her consent. Before they chose that name, they had every reason and every resource to know better. For a global commercial enterprise like defendants, searching the Federal Register for conflicts before adopting a new mark is not an extraordinary precaution. It is the baseline. A single search here would have returned plaintiff's registration. If defendants missed it, the USPTO did not. On November 5th, 2025, the office refused to register the life of a showgirl, finding it confusingly similar to plaintiff's mark and citing her registration by name and number. But defendants did not withdraw the application. They did not modify the mark. They simply continued selling goods under the very designation. 8 of 10 Google autocomplete results for plaintiff's exact registered mark now redirect to defendants. And that same search on YouTube returns 9 consecutive hits for defendants before a single result for plaintiff. This is textbook reverse confusion, where a junior user's commercial dominance systematically displaces the senior user's mark in the mind of the public until consumers come to believe the originator is the imitator. This motion does not ask the court to break new ground. Plaintiff is a senior trademark holder whose registered incontestable mark is being infringed by the very designation the USPTO refused to register, citing plaintiff's mark as the basis for refusal. In bringing this motion, plaintiff has simply followed the lead of the federal agency charged with evaluating exactly this question, and followed defendants' leads as well. Defendants are among trademark law's most prolific enforcers, having filed multiple federal actions claiming irreparable harm when others infringed their marks, and obtained injunctive relief on exactly that basis. The same principle should apply here. Plaintiff seeks a preliminary injunction to preserve her brand while this case proceeds to resolution. I mean, she is making a really good argument. I think this is fair. I mean, it's quite striking that Taylor Swift just continued to use it despite, if that is such strong evidence, like where you have literally been refused because it is similar to this patent, and they cite the number as well. But you ignore it and you just continue anyway. It's nice that someone is kind of giving Taylor Swift a bit of her own medicine here. Okay, statement of facts. Plaintiff owns U.S. trademark registration for Confessions of a Showgirl, registered in 2015 for entertainment services. Okay, so I'm just, yeah. No, I'll do it later, actually. The registration has achieved incontestable status under federal law. Plaintiff has used the mark continuously since 2014, performing her show at venues across the country and expanding the brand into television, a book, a podcast, and digital content. In August 2025, defendants adopted the life of a showgirl. What followed was not a single album release, but a coordinated commercial rollout, a brand retail storefront, individual product names incorporating the design, garment labels, and product tags bearing it, and collaborations with national brands. Defendants, through TAS, simultaneously filed a trademark application seeking registration of the designation across more than a dozen international classes covering not only musical recordings and live entertainment, but consumer goods ranging from candles and drinkware to Christmas tree skirts and disposable plates. It does feel like overkill. I'm going to have to check out these Christmas tree skirts. It's piqued my interest now. On November 5th, 2025, the USPTO refused registration, finding The Life of a Showgirl confusingly similar to plaintiff's mark. Defendants did not withdraw the application or modify the designation, nor contact plaintiff to reach an accommodation of the conflict. Instead, on March 3rd, 2026, at defendants' request, the USPTO suspended the application, while defendants continued to sell goods under the very mark the office had flagged. Plaintiff did not rush to litigation. She permitted the USPTO proceeding to run its course, afforded defendants a reasonable window to conform their conduct to the officer's finding, and watched them do the opposite. She retained litigation counsel, filed suit on March 30th, 2026, and now moves for preliminary relief. The confusion the USPTO predicted when refusing defendants' application has materialized. Consumers have referred to defendants' album by plaintiff's mark, used plaintiff's mark as a hashtag when discussing defendants' products, and treated the two designations as interchangeable, all within the brief period of concurrent use. Plaintiff's brand has been progressively displaced in the channels through which she reaches her audience. 8 of 10 Google autocomplete suggestions for her exact registered mark now direct consumers towards defendants. And on YouTube, 9 consecutive results for defendants appear before a single result for plaintiff. That displacement deepens with each day defendant's program continues. This motion seeks to enjoin it. Wow. Okay. Legal standard. A plaintiff seeking a preliminary injunction must demonstrate 1. A likelihood of success on the merits, 2. A likelihood of irreparable harm in the absence of preliminary relief, 3. That the balance of equities tips in her favour, and 4. That an injunction serves the public interest. Alternatively, a plaintiff may obtain relief by raising serious questions going to the merits and a balance of hardships that tips sharply towards the plaintiff. In trademark cases, a showing of likelihood of confusion establishes a presumption of irreparable harm. Okay, so the argument. The Rogers test does not apply here. Defendants will likely contend that The Life of a Showgirl, as the title of a musical work, constitutes protected expression exempt from trademark liability under Rogers. The argument fails at the threshold, and defendants' own filings foreclose it. The Supreme Court in Jack Daniels made clear that Rogers has always been a cabined doctrine and does not apply when an alleged infringer uses a trademark in the way the Lanham Act most cares about, as a designation of source for the infringer's own goods. That holding applies even when the use of a mark has other expressive content. The Ninth Circuit applied this holding in Punch Bowl, reversing its own prior decision and holding that Rogers is foreclosed where the defendant uses a mark to identify and distinguish its products. A trademark application is itself straightforward evidence of a source identifying use. District courts in this circuit have followed suit. In Deeslisa, I may have mispronounced that, a reverse confusion case, the court held Rogers no longer applicable, where Disney used a modified version of the plaintiff's registered mark as a character name in Toy Story 3, and then deployed that name to sell consumer goods. That the mark originated in an expressive work was immaterial. The dispositive question was whether Disney used it, at least in part, to designate source. It did. The question then is whether defendants used The Life of a Showgirl as a source identifier. The own trademark application answers it. Defendants' trademark application. Defendants filed a US trademark application seeking registration of The Life of a Showgirl across 14 international classes. The application does not cover only consumer merchandise, it covers the songs and the album. It covers concerts, entertainment service, Class 41, entertainment services in the nature of live musical performances. And it covers much more. Candles, drinkware, aprons, hairbrushes, puzzles, Christmas tree skirts, stuffed toys. Defendants have thus represented to the federal government that The Life of a Showgirl functions as a trademark for the recordings, for the performances, and for every category of consumer goods they sell under the name. A trademark application is straightforward evidence that the applicant uses a designation to identify and distinguish its products. This is not an isolated filing, it is defendant's business model. TAS manages more than 170 active or pending trademark registrations on behalf of Swift. Defendants have sought registration for virtually every album release, built branded merchandise programs around each one, and operated dedicated retail storefronts to sell goods under those designations. They treat each album title as a commercial brand because that is what it is. Having claimed The Life of a Showgirl as a source identifier for musical recordings and live performances before the USPTO, defendants cannot disclaim that characterization before this court. Defendants' product names and labeling. The evidence corroborates what the application already establishes. Defendants operate a dedicated retail webpage labeled The Life of a Showgirl shop, not as an act of creative expression, but as a retail channel deploying the designation to sell a coordinated line of consumer goods. Within that storefront, defendants use the designation as part of individual product names. The Life of a Showgirl tumbler, The Life of a Showgirl hairbrush, The Life of a Showgirl candle. Defendants further affixed the designation to product labels and interior garment tags in the positions customarily reserved for source identification. At every level of the retail operation, the storefront, the product name, the label inside the garment, the designation is doing the work of a trademark. Defendants' own litigation history. Swift and TAS have repeatedly filed federal actions seeking injunctions and seizure orders against the sale of merchandise bearing Swift-associated designations near concert venues, taking the position that such designations function as trademarks when affixed to consumer goods and obtaining federal court orders on that basis. Defendants cannot maintain that position when enforcing their own rights and disclaim it when defending against the rights of others. Under Jack Daniels and its progeny, when a designation is used, at least in part, for source identification, Rogers does not apply. Defendants have used The Life of a Showgirl as a source identifier across every commercial category in which they operate and have represented as much to the federal government. Defendants must therefore meet the infringement claim on the usual battleground of likelihood of confusion. Plaintiff is likely to succeed on the merits. I've got to say, I do think she's got a very strong case here. But yeah. Okay, so to establish trademark infringement, plaintiff must show that she is 1. The owner of a valid protectable mark, and 2. That the alleged infringer is using a confusingly similar mark. The first element is undisputed. Plaintiff owns US trademark registration for Confession of a Showgirl, which has achieved incontestable status providing conclusive evidence of plaintiff's exclusive right to use the mark. The second element turns on likelihood of confusion, which the Ninth Circuit evaluates under the 8-factor Sleekcraft test. So, similarity of marks favors the plaintiff. The following axioms define and delimit the similarity analysis. 1. Similarity is best evaluated by appearance, sound, and meaning. 2. Marks should be considered in their entirety and as they appear in the marketplace. And 3. Similarities weigh more heavily than differences. And whereas here goods are closely related, a diminished standard of similarity applies. Side by side, the similarity is self-evident. The Life of a Showgirl, Confessions of a Showgirl. Yeah, it is confusing. Both marks share the same syntactic structure, a narrative framing word resolving in the phrase of a showgirl. Both consist of standard characters and unadorned text without stylization or design elements. That is largely how consumers encounter them in practice, as plain text in search bars, social media feeds, and hashtags. A consumer scanning a screen or search result will see the same dominant phrase in the same structural arrangement. Sound. Both marks resolve on the same 4-syllable phrase of a showgirl, which carries the rhythmic and mnemonic weight of each designation. The introductory words differ, but occupy the unstressed framing position in a phrase that culminates in a shared distinctive ending. In casual speech, the register in which consumers actually discuss entertainment, both marks naturally shorten to the same anchor, the Showgirl album. The introductory words drop away. The shared element is what stays. Meaning and commercial impression. Both marks are built on common template, narrative frame, plus of a showgirl. Confessions of and the life of are interchangeable title constructions, framing devices of which the English language has no shortage. Memoirs of, diary of, adventures of. Neither framing phase is distinctive on its own. What gives each mark its commercial identity is the phrase that fills the template. In both marks, that phrase is of a showgirl. The same words in the same construction, resolving on the same noun. That phrase is not a common formulation. A search of the USPTO database returns only 2 marks using the construction, noun of a showgirl, plaintiffs and defendants. Both promise the same thing, an insider's account of a performer's experience. One frames that account as confessions, the other as the life, but the subject is identical. The perspective is identical. The overall commercial impression and intimate behind-the-curtain narrative about a showgirl is the same. The confusion evidence confirms this is how consumers process the marks. In every documented instance, the pattern is consistent. Consumers retain of a showgirl and substitute the introductory word. They call defendant's album Confessions of a Showgirl. Consumers use plaintiff's mark as a hashtag for defendant's goods. In no documented instance did a consumer retain the framing word and substitute showgirl for another term. The shared phrase is what consumers anchor to. That is what makes it dominant. The descriptiveness counter-argument. Defendants may argue that showgirl is descriptive in the entertainment context, making the introductory words confessions and the life are truly distinctive elements. The argument fails. Neither mark uses showgirl descriptively, as neither party offers traditional showgirl services. Both uses require the imaginative leap that defines a suggestive mark. But even if the term carried some descriptive resonance, descriptive elements can still dominate consumer perception, particularly when they are the only concrete noun in marks otherwise composed of abstract framing words. The confusion evidence establishes that dominance empirically. The USPTO's independent analysis. The USPTO reached the same conclusion. The office found the marks similar in appearance and similar in sound, and because the consumer is likely to focus on the dominant noun, the term showgirl, the resulting commercial impression is very similar, concluding that the proposed mark could be viewed as an extension of the registrant's brand. That determination was made not in the context of this litigation, but by the federal agency charged with evaluating exactly these questions in the ordinary course of examining defendant's application. This factor favors plaintiff. Proximity of goods and services favors plaintiff. We examine the relatedness of the parties' goods because the more closely related the goods are, the more likely consumers will be confused by similar marks. The standard does not require identical products. Goods and services are related when they are complementary, sold to the same class of purchasers, or similar in use and function. The inquiry is whether the public would attribute the parties' respective offerings to a single source. Defendant's use of the life of a showgirl spans two commercial spheres, and both are closely related to plaintiff's services. So, entertainment services. The overlap is direct. Plaintiff's registration covers entertainment in the nature of live stage performances in the field of music, singing and dancing, as well as entertainment media production. Defendant's trademark application seeks registration in the same class and encompasses every category plaintiff's registration covers. The USPTO confirmed this overlap, finding that both marks are used in connection with general entertainment services that involve musical and/or theatre performances, and that neither the registration nor the application contain any limitation on these entertainment services. This is not a close question. Consumer goods. Trademark rights are not confined to identical goods. They extend to any goods related in the minds of consumers. In the entertainment industry, audiences expect performers to sell branded merchandise in connection with their live shows. It is, as Bravado's president has described, the number 2 source of revenue after ticket sales. Indeed, defendants have built their commercial model on that expectation and have said so under oath. In a prior verified complaint, TAS represented to a federal court that branded merchandise is sold in direct affiliation with Miss Swift's name and image at concert venues in conjunction with Miss Swift's live performances. Given these ingrained expectations and the marked similarity, consumers who encounter a tumbler bearing the life of a showgirl and who are separately familiar with Confessions of a Showgirl live performances will naturally associate the two, either that plaintiff is affiliated with the merchandise, or in the reverse confusion scenario here, that plaintiff's brand is derived from the one on the tumbler. That is the injury trademark law exists to prevent. The USPTO's analysis, while addressed to a narrower question, points to the same direction. The office found an inherent connection between plaintiff's entertainment services and defendant's musical recordings, concluding that consumers familiar with plaintiff's mark would be likely to believe that registrant is authorizing applicant's use of the mark. If that inference holds for recordings, it holds at least as well as for consumer goods sold under the same designation. In the entertainment industry, merchandise and performances are not separate markets. They are two sides of the same commercial relationship, and consumers recognize them as such. This factor favors plaintiff. Strength of the marks favors plaintiffs. In a reverse confusion case, the strength of the marks analysis takes a different form. We evaluate the conceptual strength of the senior user's mark and compare it to the commercial strength of the junior user's mark. In the reverse confusion scenario, it is the junior user's commercial dominance that generates the likelihood of confusion. The stronger the junior user's marketplace presence, the more likely consumers are to assume the senior user's brand is affiliated with or derived from the junior user. On conceptual strength, Confessions of a Showgirl is suggestive. As discussed above, of a showgirl is not used descriptively in either mark. Both employ the term evocatively, requiring the imaginative leap that defines a suggestive mark. Plaintiff's federal registration independently evidences its distinctiveness, and the incontestable status of plaintiff's mark serves as conclusive proof that the mark has secondary meaning. On a commercial strength of the junior user, the disparity is overwhelming, and in a reverse confusion case, that is precisely the point. The life of a showgirl is backed by a dedicated management company, a major label distributor, a global merchandising operation generating over $900 million in annual revenue, and national brand collaborations reaching millions of consumers. In IO, the Ninth Circuit found this factor satisfied where the junior user's mark was commercially strong, as evidenced by the extensive coverage of its launch in national media outlets. Defendant's commercial strength is of a categorically different magnitude. This factor favors plaintiff. At the preliminary injunction stage, evidence of actual confusion favors plaintiff. At the preliminary injunction stage, this factor is generally not of significant relevance given the difficulty in proving actual confusion at this point in litigation. Despite these diminished expectations, and before any opportunity for discovery or a consumer survey, plaintiff has evidence of confusion arising from the brief period of concurrent use. The most probative instance is direct. For instance, a viewer of a YouTube video discussing the dispute between the parties who described having attended plaintiff's Confessions of a Showgirl production stated publicly, I personally was confused by Taylor Swift's album title. That is a consumer in the relevant market someone who knew plaintiff's brand from first-hand experience, who encountered defendant's designation and was confused by the two. Additional evidence documents the mark's functional interchangeability in the manner that reverse confusion predicts. Consumers on TikTok and Instagram have used plaintiff's mark as a hashtag when discussing defendant's products. Those consumers are not simply misremembering an album title. They are associating plaintiff's mark with defendant's goods, treating it as an identifier for defendants. The Lanham Act protects against uses likely to cause mistake or confusion as to the affiliation, connection, or association between parties, not merely confusion at the point of purchase. When a consumer uses plaintiff's mark to tag defendant's product, the marks have failed to perform their source distinguishing function, regardless of whether that consumer would, if prompted, identify the correct title. In a reverse confusion case, that is precisely the injury. The senior user's mark is absorbed into the junior user's commercial identity until consumers assume the original belongs to the newcomer. Every instance in which a consumer uses plaintiff's mark to identify defendant's product advances that erosion. The confusion evidence is corroborated by plaintiff's displacement in the digital channels through which she reaches her audience. When a consumer enters plaintiff's exact registered mark into Google, 8 of 10 autocomplete suggestions direct the consumer toward defendants. On YouTube, 9 consecutive results for defendants appear before a single result for the plaintiff. Plaintiff does not contend that algorithmic behavior is itself confusion, but autocomplete predictions are not random. They reflect the actual aggregate search behavior of millions of consumers. This displacement is the mechanism through which reverse confusion operates. Defendants' overwhelming commercial presence is progressively overwriting plaintiff's mark in the digital infrastructure consumers use to discover her. This factor favors plaintiff. Marketing channels use favors plaintiff. Marketing channels converge when the general class of purchasers exposed to the products overlap. Both parties offer entertainment to the same consumers, audiences for live performances, music, and entertainment content. Both distribute through the same digital platforms, including television, YouTube, and social media, and both perform in overlapping entertainment markets across the United States. This factor favors plaintiff. Degree of consumer care favors plaintiff. This factor considers the sophistication of the consumers, including whether a reasonably prudent consumer would take the time to distinguish between the two product lines. Purchasers of inexpensive goods are likely to exercise less care, thus making confusion more likely. Consumers encounter both marks most frequently through free online content, where the degree of care is at its lowest. A consumer scrolling through search results or a social media feed is making a split-second judgment based on general impressions, not pausing to investigate provenance. It is in precisely this environment that the documented confusion has occurred. Confusion is equally likely at the retail level. The parties' consumer goods, t-shirts, candles, barrettes, books, are inexpensive items that invite impulse buying, not careful deliberation. This factor favors plaintiff. Defendant's intent favors plaintiff. Intent is established if the defendant knew of the mark, should have known of the mark, failed to conduct a reasonably adequate trademark search, or otherwise culpably disregarded the risk of reverse confusion. The record leaves no room for doubt. Defendants are charged with constructive notice of plaintiff's mark, which has been on the principal register since 2015. Their own clearance infrastructure makes actual knowledge a near certainty. TAS manages more than 170 active or pending registrations on behalf of SWIFT. Trademark clearance is foundational to an operation of this scale. Defendants either found plaintiff's mark and proceeded regardless, or failed to conduct the search that basic practice demanded. Either way, the risk of confusion was culpably disregarded. Any remaining ambiguity was eliminated on November 5, 2025, when the USPTO refused registration of The Life of a Showgirl based on a likelihood of confusion with plaintiff's mark, identifying her registration by name and number. Defendant's response was not to reconsider. They did not file a response arguing the marks were indistinguishable, the ordinary course for an applicant who believes the refusal is wrong. Instead, they requested suspension, effectively parking the application while continuing to sell goods under the refused designation. This factor strongly favors plaintiff. The likelihood of expansion favors plaintiff. Inasmuch, a trademark owner is afforded greater protection against competing goods, a strong possibility that either party may expand his business to compete with the other will weigh in favor of finding that the present use is infringing. When goods are so closely related, any expansion is likely to result in direct competition. The parties already operate in overlapping markets, as the proximity analysis demonstrates. But even setting that overlap aside, this factor independently weighs in plaintiff's favor because both parties continue to expand under their respective designations. Defendants have already extended The Life of a Showgirl well beyond a musical release into consumer goods and commercial collaborations with national brands. Their trademark application makes the intended scope explicit. Registration across more than a dozen classes covering goods ranging from ponchos and disposable napkins to Christmas tree skirts and aprons, in addition to musical recordings and live entertainment. This is not a designation tethered to an album, it's a commercial brand designed to reach every corner of a consumer's life. Defendants have not yet toured in support of this release, but when they do, the designation will enter the live entertainment market, the very market in which plaintiff has performed Confessions of a Showgirl for over a decade. On plaintiff's side, the trajectory of the Confessions of a Showgirl brand has been one of steady organic expansion from a column to a live show, book, podcast, and video content. Defendant's trademark application now claims rights in every one of those categories and dozens more, ensuring that wherever plaintiff expands her brand, defendant's confusingly similar designation will already occupy the field. This factor favors plaintiff. Even if this court were to find that plaintiff has raised only serious questions going to the merits rather than a full likelihood of success, relief would still be warranted. Under the Ninth Circuit sliding scale approach, a preliminary injunction may issue where serious questions are combined with a balance of hardship that tips sharply towards the plaintiff. Here, plaintiff is a solo performer whose sole trademark is being subsumed by a global commercial enterprise. The balance of hardships could not tip more sharply. Plaintiff is likely to suffer irreparable harm. In 2020, Congress restored the presumption of irreparable harm to the Lanham Act, providing that a plaintiff seeking a preliminary injunction in a trademark case is entitled to a rebuttable presumption of irreparable harm upon a finding of likelihood of success on the merits. That presumption places the ultimate burden of production on the question of irreparable harm onto the alleged infringer. Defendants may overcome the presumption by demonstrating, for example, that plaintiff delayed in seeking relief, that her injuries are purely pecuniary, or that defendants have ceased the infringing activities. None of those circumstances obtains here. No delay. Upon learning of defendant's adoption of the designation in August 2025, plaintiff consulted with counsel. During this period, plaintiff continued to perform and create content under her brand while monitoring defendant's use of the designation. Rather than rush into litigation, plaintiff permitted the USPTO examination process to run its course. When the USPTO refused defendant's application on November 5th, 2025, and then suspended it at defendant's request in March 2026, it became clear that defendants had no intention of conforming their conduct to the office's determination. Plaintiff retained litigation counsel, filed suit on March 30th, 2026, and now moves for preliminary relief. That timeline, monitoring an active administrative proceeding, affording defendants a window to cure and filing when they expanded, instead reflects diligence, not delay. And that's quite important, actually. Just to sort of make a point here, right? Firstly, litigation is incredibly expensive, and when you're going up against Taylor Swift, who has unlimited resources, and you are, you don't have that money or power. What commonly happens is the bigger party will then just, file and just frustrate the case, and you end up spending all your money on frivolous motions and dealing with them, and then you run out of money and have to withdraw the case anyway. So if this plaintiff hasn't got much resources, she wants to be sure of her case, and litigation should be a last resort. Like, there should not be a rush to go and file a lawsuit. You should be trying to deal with these things. You should monitor to make sure that actually you have got a case, and she's done all the right things. I don't see that there is a delay here at all. But I'm happy with the way she's kind of conducted this. As she says, she let an administrative process play out first. Well, that's kind of critical anyway, because she's now heavily relying on that process and the outcomes of it. So she's done the right thing. And I think, one of the big things she points out is, the Taylor Swift's application was refused. She then requested that it be suspended. She didn't try to renew it, change anything. She didn't try to appeal it, nothing. She just asked for the application to be suspended, and then she's continued, business as usual. Has no intention of, adhering to the outcome of the USPTO's decision. So that's that. And again, these are strong points to bring and put into a lawsuit, but you got to wait for them to happen. So she's done the right thing. Not purely pecuniary. So plaintiff's central injury is not lost revenue. It is the progressive erosion of her mark's source identifying function. In a reverse confusion case, the harm is not that the plaintiff loses customers to defendants. It is that the plaintiff loses the meaning of her mark entirely. No retrospective damages award can restore a mark's source identifying capacity once consumers have come to associate it with someone else. That risk is acute here, where plaintiff, a solo performer with a single trademark, faces a junior user backed by a dedicated brand management company overseeing more than 170 registrations, a major label distributor, and a global merchandising operation. The goodwill plaintiff has built over 12 years of continuous use cannot be recaptured through damages once it has been dissipated. And no damages award can recalibrate a search algorithm or undo the associations consumers form as a result. Not ceased. Defendant's use of the life of a showgirl as a trademark is ongoing. As of the filing of this motion, defendants continue to operate a dedicated retail storefront under the designation and to sell goods bearing it. The commercial program is expanding, not contracting. The presumption of irreparable harm is unrebutted. The balance of equities favours plaintiff. All right, we are getting close to the end of this now. The balance of equities requires the court to balance the competing claims of injury and consider the effect on each party of the granting or withholding of the requested relief. Here, both the harm to plaintiff and the burden on defendants weigh decisively in plaintiff's favour. The harm to plaintiff absent relief is existential. Confessions of a Showgirl is not one mark among many for plaintiff, it is the only one she has. She has built her professional identity under it for more than a decade, and she has no portfolio of alternative brands, no corporate backing, and no global marketing operation to compete for consumer attention. Defendants have all of these. That asymmetry is directly relevant to the equities, and it tips in plaintiff's favour. If defendants' use continues unchecked, the harm is not merely economic, it is the progressive erasure of plaintiff's ability to be recognized as the source of her own brand. That harm deepens with each day the commercial program continues and becomes increasingly harder to reverse. The burden on defendants is self-inflicted and manageable. Plaintiff does not minimize the practical implications of the requested relief. Defendants have built a commercial program around the life of a showgirl, and an injunction would require them to modify it. But the burden must be assessed in context. First, it is a burden of defendants' own making. Defendants' clearance infrastructure, the same operation that manages more than 170 trademark registrations, would have identified plaintiff's mark before the designation was adopted. The USPTO confirmed the conflict when it refused defendant's application on November 5th, 2025, identifying plaintiff's registration by name and number. Defendants expanded the program anyway. Every dollar spent after the refusal was spent with knowledge that the designation was confusingly similar to a mark belonging to someone else. Courts routinely discount self-inflicted harm in this analysis. Second, the injunction is scoped to what defendants themselves have claimed as trademark use. It reaches goods and services within the classes identified in defendant's own trademark application. It does not affect any other defendant's other trademarks or products. The goods that do bear the designation need not be destroyed or recalled. They only need to be removed from active sale pending resolution. Finally, the timing favours early relief. Defendants have not yet toured in support of this release. No dates have been announced. No tickets have been sold. No reliance interests in live entertainment, plaintiff's core market, have attached. If the court acts now, it can prevent the designation from entering that market. If the court waits, defendants will expand further, consumer associations will deepen, and the equities will shift. And I think, right, it's important. Like, Ashley is obviously our PR guru. She actually has a post on X, so I'm going to just show you it because it's not just the name, right? I just want to show you how similar this is. The same colorings, even. You know, it's not just the name sounds similar. Taylor Swift has actually used the same font colors, the kind of teal blue, the red, words, text, and to some degree, even the pose, and the outfits, like it's just so close, right? And the only thing that's different is the people. But that's what this lady is kind of saying is like, well, Taylor Swift's a fucking giant, I don't stand a chance. And if she keeps going, I'm going to lose the only brand I have. And that is not fair. And she's right. But I think for a visual, because I love visual representations, right? To see it in action, how much has actually been taken from this lady. And it goes beyond just, the actual words, of a showgirl. All right. Bond. Pursuant to Federal Rule of Civil Procedure 65C, the court should also set a bond commensurate with the circumstances of this case. Plaintiff is a solo performer who has brought this action to protect the single trademark under which she has built her career. A bond set at a level that would effectively foreclose preliminary relief would deny plaintiff access to the very remedy trademark law provides. The injunction requires defendants only to cease using a designation the USPTO has found confusingly similar to plaintiff's registered mark. The risk of a wrongful injunction is low. The burden of compliance is manageable within defendants' existing operations, and plaintiff's ability to vindicate her rights should not turn on her ability to post a bond calibrated to the scale of defendant's enterprise. Plaintiff respectfully requests that the court exercise its discretion to set a bond reflecting those circumstances. A preliminary injunction serves the public interest. The public interest in not being deceived or confused about a source or identity favors granting injunctive relief. The public is being confused now. The USPTO reached the same conclusion when it refused defendants' application on the likelihood of confusion grounds. And I am going to just take you to that, actually. Let's do that. Okay. I'm going to go just to the, there you go. Trademark Act, Section 2D, partial refusal. Registration of the applied for mark is refused because of a likelihood of confusion with international classes 9 and 41. The mark in US registration number, and that's the plaintiff's registration number there. Confessions of a Showgirl. So there you go. And they talk about it. I'm not going to go through all of this. Like the subheading there is the marks are confusingly similar. I'm going to just go to the bits that she has highlighted. Oh, right. The marks are identical in part, since they both consist of the terms of a showgirl. So the marks are similar in appearance and similar in sound. Somewhat similar. So the marks are similar in appearance and similar in sound, somewhat similar. Sorry, I'm just reading it as it is literally written. It makes no sense. Similarity in sound alone may be sufficient to support a finding that the compared marks are confusingly similar. While the terms life and confessions are different, the resulting commercial impression by combining the life with of a showgirl and confessions with of a showgirl is very similar. In neither case is there the idea of a familiar phrase in colloquial American English. So a consumer is not likely to have a specific reaction to either mark. Instead, the consumer is likely to focus on the dominant noun, the term showgirl. The shared term contributes more to the commercial impression of the marks. In fact, the proposed mark could be viewed as an extension of the registrant's brand. Turning to the relatedness of the goods and services, an analysis of the parties' goods and services and their trade channels reveals that both marks are used in connection with general entertainment services that involve musical and/or theatre performances. Both marks refer to music performances and theatre productions. Neither the registration nor the application contain any limitations on these entertainment services. As to the relatedness of applicants' Class 9 goods and the registrant's Class 41 services, musical artists can be the source of both live musical performances and recordings, as evidenced by the website of various musicians. They commonly promote both their musical performances and their recordings on their websites, as shown by the attached excerpts from the following websites. In fact, there is an inherent connection between the recordings in Class 9 and the performances recorded on them, which is evidence of relatedness as well. Thus, purchasers familiar with the registrant's mark, Confessions of a Showgirl entertainment performances, upon encountering applicants' musical recordings and performances offered under the very similar mark, The Life of a Showgirl, are likely to believe that registrant is authorizing applicants' use of the mark, and assume that applicants' goods and services are therefore licensed by or in some way associated with registrant. I'm not sure if that's... Yeah, I'm just going to go back now because I think that's it. So that is the decision from USPTO to Taylor Swift's attempt to register the trademark for Life of a Showgirl. Okay. Numerous instances of consumer confusion have been documented. Consumers are referring to defendant's album by plaintiff's mark, using plaintiff's mark as a hashtag for defendant's products, and encountering such results that treat the two designations as interchangeable. Every day that defendants continue to use a confusingly similar designation on goods sold to the public extends the confusion further. Enjoining infringing conduct promotes the public interest in protecting trademarks generally. That interest does not diminish because the senior user is small and the junior user is large. Indeed, the doctrine of reverse confusion is designed to prevent the calamitous situation where a larger, more powerful company usurps the business identity of a smaller senior user. A preliminary injunction should issue. So for these reasons, blah, 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 you should give us what we've asked for. Incredibly well drafted filing, sets it out wonderfully. I will have a look through Taylor Swift's response. I do know it was quite aggressive. But I think, like I say, when I showed you the side by side from Ashley's X account, it's not just the actual words, it is the look, the image. It's it's like she's taken the whole thing and just swapped out Marine flag for Taylor Swift. And maybe thought, well, if I change a word here or add a word there, then that'll be enough. And it's not. It's like plagiarizing, someone's entire coursework or essay for, university or something, and then changing the odd word here and there, thinking that the detection software is not going to pick it up. It does pick it up. And it's been, the federal authority that specifically looks for these similarities has picked it up, and then she's not just stopped there. She has actually gone and looked for, service users, consumers, fans of both of these artists who have expressed confusion. And she's come with, a whole treasure trove of evidence to back up exactly what she's saying. This is in very strong filing. And I do think at minimum, there should be a preliminary injunction, at least until this is all resolved, because I do think that her complaint has got serious merit. Okay, I'm going to come back with my next video, which will be Taylor Swift's response.